When a justice of the United States Supreme Court in Ketanji Brown Jackson looks to her fellow colleagues on the bench and says to the right wing, I think you're playing Calvin Ball where there's only two rules. One, there's no fixed rules. And two, the Trump administration always wins. You know, we got a problem. We got a new ruling coming out of the United States Supreme Court against American health, against American public health, against the medical breakthroughs in which two separate 5-4 majorities made what appear to be conflicting rulings about Judge Young's decision in Massachusetts to stop the Trump administration from blocking $800 million going to the National Institute of Health programs under some false flag of, oh, it's DEI. It's not DEI. It's medical breakthroughs. This is about the Supreme Court supporting the purge being led by the worst Kennedy ever, Robert F. Kennedy Jr., and allowing it to happen under some procedural mess of an order that I'm going to break down for you right here. I'm Michael Popich, and you're on the Midas Touch Network. Okay, let's get to the new order that just came out. Headline of the order is two separate 5-4 majorities on the United States Supreme Court. At least one of them blocks Judge Young's decision, which said that the Trump administration could not cut off $800 million worth of medical and scientific breakthrough research. And now this 5-4 majority led by Alito Thomas Gorsuch, Kavanaugh, and Amy Coney Barrett says, well, I don't think the judge had jurisdiction. I think the judge that case should have been filed in the Court of Federal Claims. He had no jurisdiction, and therefore the funds can disappear. And these funds, as the 16 states that brought this case and the American Public Health Association said can't be replaced. This is research that we're in the middle of. Close the lab, close the scientific research. Close the books. Doesn't matter where you are in them. End the breakthroughs. We don't want breakthroughs in America. Look at Donald Trump's assault on public health. Not only do we have an assault on public safety by Donald Trump in which he's trying to turn the military into police officers, right? Making us more unsafe, not safe, and diverting resources away from public safety. We have the administration that is the worst administration about public health in our history. He puts Robert F. Kennedy Jr., who's a science denier, a medical denier, a non-scientist in charge of public health. He fires everybody at the CDC. He fires everybody about vaccine recommendations. He guts the National Institute of Health. And now he's celebrating in glee because $800 million that should have gone to medical and scientific breakthroughs to make us healthier and safer have been cut. What kind of ghoulish, depraved administration are we watching? We know the answer to that. What just happened in the case? In the case, 5-4, listen to this. 5-4, the group I just told you said, cut the funding. Judge Young, you were wrong. You should never have taken that case. You don't have jurisdiction over that case. But a separate 5-4 with Chief Justice Roberts in that group, Roberts again with Amy Coney Barrett and the three liberal judges, the three moderate judges, they said, but Judge Young, you were right to find that the guidance around the NIH policy was improperly issued. So let me get this straight. He had the jurisdiction, according to 5, the majority of the Supreme Court, to find that the guidance was unconstitutional or a violation of the Administrative Procedures Act. But by another 5-4 majority, he doesn't have the jurisdiction to do anything about the funding cuts. Are you kidding me? This is like the purge. So two separate groups, this is how wrapped around their axles. This is how, from a jurisprudence standpoint, how lack of integrity, lack of sincerity, lack of credibility the MAGA Supreme Court actually is. They're just reversed engineered this. Gorsuch even went so far in his opinion to come out and say something like Judge Young was being defiant because he should have followed our lead in a case from a couple of months ago involving the Department of Education. See, the Department of Education was also a QTO off of grants in a case involving California. That seems now to have established new precedent that even though it was another emergency application with a 2-paragraph order that Judge Gorsuch said, Judge Young, you should have followed our our president and Department of Education versus California. Trump administration is allowed to cut off funding, and you have no jurisdiction. It should go to a court of federal claims, and you should have followed that. Now, Judge Ketanji Brown Jackson, in her dissent, 16 pages, by the way, I posted the whole thing in Legal a Substack so you can read it. She said, "What am I watching here?" First of all, this is Calvin Ball, from Calvin and Hobbes. This is Calvin Ball. There are no fixed rules. That's the only rule. Except there's one more rule. Trump always wins. She said, if they have jurisdiction over the guidelines not being proper, then they, by extension, should have jurisdiction over the funding that comes from the guidelines. Even Chief Justice Roberts said that, and she also said, "I didn't understand till now." This is also sad that she said, "I didn't understand till now the impact of how the California case was going to be used in future cases," because all the majority pointed to was, well, the California case says the court doesn't have jurisdiction. Why are we here? This is what she says in her ruling. As it turns out, the court's decision was even bigger mistake than I realized. The court's reasoning in California was not only at least underdeveloped and very possibly wrong, but also evidently resolved more than the jurisdictional dispute over the particular education-related grants at issue in this case. In other words, it's a cautionary tale about using the emergency docket because you get a very small opinion with a convoluted procedural outcome, and therefore but now it's being used in future cases, she thinks wrongly, where the court is now bending over backwards to accommodate. So what's the end result? The end result is that the Supreme Court, using a ruling that they made a couple of months ago in a 2-paragraph order, forcing these kind of grant cutoff cases to be sent to a specialty court, are now using that to excoriate and lambaste federal judges who have the temerity to take up the jurisdiction of the case and make the ruling. And that's the Calvin Ball aspect called out by Ketanji Brown Jackson. And how many cases do I have to talk about where Ketanji Brown Jackson is the moral voice of the Supreme Court, the voice for all of us in her dissents? She's speaking to history. She's speaking to the future. She's speaking to law students in training, but she's not prevailing as of yet because she doesn't have the votes. But we're now seeing two things with this Trump administration: the complete dismantling of public safety and any concern for the America's life, health, or safety, and a complete dismantling of our public health system, our research system. Medical breakthroughs come through two places: institutes like the National Institute of Health, the CDC, and other government-funded quasi-governmental entities under the control of the government. That's one. And major public universities. That this attack on Harvard, on Columbia, on Duke, on the rest is just an attack on science and free thinking. It's just an attack on medical breakthroughs. Shut the labs. Shut the next cancer cure. Shut the door to the next genetic defect cure, stroke, common cold, you name it. Because Donald Trump's attacking and taking away billions, hundreds of billions of dollars from public universities. And now he's defunding the National Institute of Health. And the Supreme Court MAGA is letting him get away with it. So that's the takeaway. Supreme Court hates you. The MAGA Supreme Court does not care about the average American or any American other than themselves. That's where we're at right now with the reputation of the Supreme Court. I'll continue to follow it all right here on the Midas Touch Network and on Legal AF. Hit the free subscribe button, Midas Touch and Legal AF Sub, Legal AF YouTube, and Legal AF Substack as well. Until my next report, I'm Michael Popp. Can't get your fill of Legal Amy. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or an oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting, we got interviews, we got ad-free versions of the podcast and hot takes where Legal AF on Substack. Come over now to free subscribe, music,